I've got about 12 after. We're going to start the Setzler Subcommittee at 3:15. Ladies and gentlemen, welcome to the Setzler Subcommittee of Non-Civil Duty. We do have a hard stop today at 4:30, so forgive me in advance. We will not touch everything that was on the agenda today. I will say this, Chairman Harden, do you have, I want to make sure staff's got your drug update bill. That's more of a housekeeping measure we do each year. If we don't have that, I'd like to get copies of that made so we can get that in the process. I know you're... just to those who are fans of the non-civil subcommittees, we're going to have quite a few hearings in the next couple legislative days. We've got some bills stacking up. There's a lot of things that take time and attention, so I would anticipate something Tuesday, possibly Wednesday, and I think
probably Thursday and Friday.
Yeah, so yes, we're twins here. So want to be sensitive to issues of calendar. But I had told Chairman Harden I'd like to take up the drug update bill, so if we could just stand at ease for a moment, let's take that one first, and then we'll move on with the others kind of in our standard batting order. Tell you what we'll do while we're waiting on staff. We're going to go ahead and take up HB 825, Death Investigations, Chief Medical Examiner. Representative Williams, welcome to Non-Civil Judiciary. HB 825.
Yes, sir. Thank you, Mr. Chairman and members of the committee. I'm here before you with House Bill 825, and I have with me Dr. Jonathan Eisenstadt, who's Chief Medical Examiner for the Georgia Bureau of Investigation. And what this bill is to allow the Chief Medical Examiner to inter and disinter unidentified human remains. And this will put up space at the crime lab that they have, and then of course Dr. here is the expert, and if you wish to address him or me, either one on any questions. From what I understand, the DNA has been done on these cadavers, and these are Jane Doe's, Joe Doe's, that's never been claimed by anyone. But in the future, if someone wished to claim the deceased, the cadaver, then it should be disinterred and turned over to the family.
Okay. Welcome. Could you speak to the issue, give us a little background on it? And,
So currently we have 260 unidentified remains, and they're all skeletal remains.
Okay.
They're housed at the headquarters on news office, and we have already done biophysical profiles on them. We've already removed the appropriate amount of bone for DNA analysis. So basically what this would do is, afford these individuals inappropriate burial. And if in the future a family member or a loved one or law enforcement were to come forward and have an idea of who the individual may be, then we could disinter that individual after DNA analysis is proven that's who it is. We've already looked into areas where we could inter and disinter the individuals. And again, we would do it in an honorable fashion because they are someone loved.
what's the process today? I mean, walk us through, what this bill's seeking to address an issue of something we can't do today. What is the process of that were needed to be done under our current statute?
So if we wanted to inter an individual where we don't have the legal next of kin's authority or approval, basically I'd have to get a court order for each individual to be interred. And this would allow me or one of my doctors to approach me and give me the authority to say, we've done everything we needed to do. We've spoken to local law enforcement. We've entered all of the statistics of that individual into what's called NAVIS, which is a national unidentified system. It goes throughout the entire country. And once we've exhausted all possibilities of identifying that individual today, and law enforcement has agreed that there's nothing more that can be done, it will give me the authority to bury that individual.
And if I could add also, Mr. Chairman, there's going to be no fiscal impact to the state. The GBI has the funds and has the assets already to handle this.
What's the reference in? I tell you what. Let me do this. Members of the committee, are there questions about 825? Chair recognizes Representative Price for question.
Thank you, Mr. Chairman. Several questions. One about obviously the cost. You have to find a place and the cost of burial, presuming that they would be put into a casket or what have you.
Right.
So there's considerable cost there, I would think.
So we've, if you don't mind.
Well, what has happened, a lot of these, like you said, were skeletal remains. They will be placed in containers, and sometimes it may be just a skull. It may be just minor skeletal remains, not a full body. So they, in an actual adult vault, there could be actually about 4, maybe 5 even, remains placed into that single vault. What we're doing, right, and what I volunteered to help them with, is going directly to the vault manufacturer here in Atlanta that manufactures the vaults, and so they can deal directly with the manufacturer on a wholesale basis. So it's not going out for retail. Also, we're looking, and I suggested to them that we find a municipal cemetery rather than a private perpetual care cemetery to try to get some city or county government to allow them. They're only going to need, I think, about 20 graves. So even though it's 260 skeletal remains, they're only going to need about 20 graves. Is that correct?
That's correct. And I actually did an analysis already with the remains, how many vaults we would need, how many headstones we would need. And currently to inter the 260 that we have at headquarters would cost a little less than $40,000 right now. And with the caveat that if we had to disinter, then obviously we would absorb the cost at that time because we would have to get a new vault to put the remaining individuals back in. But currently to inter every individual that's unidentified, it would be about $40,000 right now.
Thank you. Mr. Chairman, may I ask my second question?
You got the floor?
This one pertains to the ongoing effects of this bill, given that you have a current problem you're trying to address with the 260, but ongoing, I just wondered if there should be any sort of minimum time frame that might be required prior to interring.
Sure. And so really the reason that when I was looking over this, I didn't put a specific time frame on it is because every unidentified individual case is unique within itself. If it's remains that when we examine the remains, we're concerned that this was a homicide or some sort of inflicted trauma, we will probably want to hold on to those remains longer before they're interred. The wording that I envisioned was when the medical examiner and the local law enforcement were comfortable that at that time there was no further investigation that could be done, that would be when we would inter the individual. But we wouldn't do them one at a time. We would do them so we could, for fiscal reasons, we would do them at maybe 4 individuals at a time so we could open a vault and close it at the same time.
And this would be well marked so that a disinterring could occur pretty easily.
Absolutely. They're called flower boxes, is where the skeletal remains are kept. Each one of those are labeled inside, will be labeled outside. And then we will have in our system at GBI which individuals in which vault. And then there will also be headstones that will have the numbers of which individual, no names because we don't know who they are.
Mm-hmm.
So it would be very easy to disinter just those individuals.
Thank you.
Chair recognizes Representative Gonzalez for a question.
Just to clarify, who would be the ultimate agency in charge of this?
So that would be the GBI Medical Examiner's Office.
Thank you.
Representative Price, I think what we failed to mention is some of these remains have been at the crime lab for 25, 30 years. So they've been there a long time, from
Yes,
what
sir.
I understand.
That's correct.
The law still would stand for any future. That was my concern.
Right.
What's the just for information? What's the process? You've got these remains. You're able to do DNA analysis on them. Has there been a effort to take the DNA and use that as a mechanism to find family members? What is the normal process?
Sure. So whenever we have unidentified remains, we call in an anthropologist. The anthropologist does standard measurements, and those measurements go into a program, a computer program. At the same time, we will take a wedge of long bone, usually the femur, the thigh bone, and that's where you get the best DNA. That's sent to the DNA lab. That'll be run through the DNA system, and then it'll be inserted into that national database, which is called NAMUS, N-A-M-U-S. And that database has everything from the clothing, if there was clothing with that individual, to the measurements of their bones, to dental work, to the DNA.
And we've actually had a few hits. I believe over the last couple of years there have been 3 hits to identify those individuals. All of that is stored into a system, and then we obviously have to have someone else either supply some sort of DNA, like a hairbrush or something found at a crime scene, to link the decedent's remains to that individual.
The line that says the chief medical examiner on line 12 shall have the authority to disinter remains interred person to subsection A of the code section. Is there a, I don't have any issues with this personally as a member of the committee, I guess. Is there value in a judge being able to order these things? I mean, I guess the judge now has the ability to do that. Do we need to state in this code section the judge has the authority to do this? Is there the prior code section? Okay, so that's covered. Thank you. Any further questions from members of the committee? Hearing none, Representative Williams, any further people you want to call to speak to this?
Is anyone else? No. Does any of the committee have any other questions? Or?
I don't see any.
Okay.
That said, what's the pleasure of the committee?
Move to pass.
Can I move due pass and second? Any discussion? Hearing none, all those in favor of passage or sending HB 825 forward to full committee with the due pass recommendation signify by saying aye.
Aye.
All opposed? Pass unanimously. Thank you.
Thank you.
Thank you very much. Thank you, committee.
Chair would like to recognize Chairman Harden with HB 830. Sure. Okay. So you're leaving at 4? Okay. Okay. Gotcha. You're next. I wasn't sure whether you were coming late or leaving early, but
We have to go to the same meeting.
understand. Let's do this. Let's hear from Chairman Harden. I don't think this will take an awful lot of time unless Chairman Harden makes me pronounce some of these isotopes he's presenting.
You not asked me to, and I won't ask you to.
That's a rite of passage. You know, that's a rite of passage in this committee. You have to pronounce the first isotope you present. So.
All right. Well, Mr. Chairman and committee members, this is the annual drug update, and basically it comes from the GBI. The 3 things involved. We have dangerous drugs, and then we have controlled drugs that are classes 1 through 5. Now, the first 4 sections of this bill deal with class 1 drugs, which are totally illegal drugs. And the first section is fluorofenmetrazine, if that gets me enough pronunciation. But 1, 2, and 3 are just simple. Sometimes we find that people find chemical ways to make the same drug but add a radical or a chemical group to it to make it different so that it doesn't fall under the law. And that's what those straighten out there. Section 5 is on dronabinol. Now, dronabinol is tetrahydrocannabinol. And you probably, since you copied my thing, you see my notes there. But it does contain THC, but it's a synthetic THC. And what this is doing is making it available in an oral solution. And I'm just wondering if this is a move toward trying to find a drug that will help these people that we've been talking about with marijuana, because dronabinol is a synthetic marijuana.
Is dronabinol right now a Schedule 1?
No, dronabinol is Schedule 2. So it can be prescribed. 1 is just totally illegal. 2 is by prescription only, but it is highly restricted.
I'm just making sure. So we're not removing dronabinol from one place to another then?
No, we're not
We're
moving
naming
it.
it for
No,
first-
they're just making an oral solution. It has been in a capsule form, and they
thank
just
you.
make an oral solution. Section 6 begins with dangerous drugs, they call them. And dangerous drug is a drug basically that a physician may write. It requires a prescription, but it is not a controlled substance in the fact that it can be refilled more times than a controlled substance, and just some exceptions there. So most of those drugs, and those would be the ones we wouldn't want to pronounce here today, and we might say something that would be offensive to somebody. But those drugs are basically, that's the generic name. The trade names of those drugs will be something else. But these are drugs that have been developed during the year for different conditions, and they have to be put on the list so that the physicians then can write legal prescriptions for them. And that's all those are. Section 7 is just it's some cleanup language. In fact, most of those are where there is a drug already on the list. Look at Section 9. That's the most, this easiest one to pronounce. But lidocaine topical currently is a dangerous drug. But now I think they've added if you go 4% or less, then it can be sold without a prescription. So it comes off the dangerous drug list. But really nothing exciting in this bill this year, but be glad to answer any questions you have.
Any questions for the author? Hearing none, I'd like to thank GBI. I made a mistake. I refer to these not as compounds but isotopes. I don't think there's anything radioactive here. So I caught myself on that, by the way. So my chemists in the back were polite and not laughing out loud at me there, Mr. Chairman. So if there's no further questions, anyone care to speak on HB 830? Anyone care to speak? Hearing none, appreciate your carrying this for us, Representative Harden. With that, what's the pleasure of the committee?
Second.
Move to pass and second. Any discussion? Please, Representative Price.
On section 9, so this is not changing a drug on the dangerous drug list,
No.
but changing the concentration to a higher concentration only.
No, what I think it does is says in a lower concentration, it can be sold over the counter. It's a dangerous drug, but doesn't require a prescription, basically. And I believe that's what that is. I didn't look up the complete section to see that, but lidocaine topical is it's available over the counter already, but in higher concentrations, it is a dangerous drug. They went from 25 to 40. Used to get 25 milligrams over the counter. Now it's to 40. So they just
Right. My
loosening.
question, I guess, is
Yeah.
why does it say or less? Because clearly 25 milligrams per gram
Well,
is
what they were doing, they were
less.
increasing what could be legally sold, as I understand it, from 25 milligrams. It can be sold without a prescription now. That moves up to 40. But anything above 40 then would require prescription.
Okay, so
still.
it's just on the dangerous drug list, but it can be
Yeah,
utilized.
yeah.
Okay, thank you.
2.5% concentration, 4%.
Yeah.
Any further questions? Hearing none, all those in favor of sending HB 830 forward to full committee with due pass recommendation, signify by saying aye. Aye. All opposed?
Thank you, Mr. Chairman.
Chairman Welch.
Thank you, Mr. Chairman. Members of the subcommittee, let me unfortunately begin with that. I'll probably have to leave in about 10 minutes. So what I'll do is I'll just give you an update, and then those that may want to speak on the bill for or against the measure, I will have to circle back with them, and it's my commitment to you that I will do that. So if there's testimony that you hear that after I leave that needs to be addressed, then we'll work with whomever that is.
And just to be clear, we're working off of LC version 297889S.
Correct.
When was this finished up and provided to committee?
This was provided to the committee yesterday, and the only changes in it from the version you had before was we added the subscription fee was $100, and now and this is on line 49. It was
If I could, before you get going, people in the seats, is 7889, is that a version you guys have seen and had access to take a look at? Anybody? No? Can we get some copies out? Pass around while we take. I think part of the exercise is the people being able to speak to this. I'm fine to have you present it and have other folks talk to the committee, but I want to be sensitive to that dynamic. If that means we can't cover everything, we'll do our best. But I do want to give people a chance to see it.
okay.
What changes? Andy, the changes are not.
Well, I'll just wait till everybody's got it so they can read line by line.
I only have 3 copies. It's going to take a while to print this one.
Just present to the committee. I want to make sure they have access to
Okay, all right.
carry
Well,
away.
the changes are, the easy one is at line 49. The subscriber fee was $100. We have increased that to $500. So it's a not to exceed limit. It could be lower, but, and then the other one was that in lines 42 through 47. This is what happens when someone is no longer employed, licensed, permitted. This language here needed to mirror the language that is in lines 23 through 25, all the way down through line 29. So we just made those two language sections match. And the reason why is because this bill is, we refer to it in a colloquial term as being the wrap back bill, because what it does is it affords the GBI the authority to retain fingerprints of those who have been employed or contracted with or licensed or permitted by the state. It is both a protection against liability for the state, but it's also to ensure the safety of those departments which may want to subscribe to this. So it is not mandatory. It just creates the authority for the GBI to collect and maintain those fingerprints, and coincides with federal law, as well as checking those fingerprints on an automatic basis within GCIC and NCIC, so that if an employee, let's just say if a employee of DFAX is later picked up for and arrested for a crime that involves a child, and then that hit, if you will register back with GBI, and GBI can then notify the DFAX that they have this issue with one of their employees, and it does that in almost real time. So we will know quickly whether or not there's an issue with one of the employees that has care over a child. This would also could apply to elder abuse. There are agencies that are here today. GBI is here today to speak more in detail of how this functionally works. The reason for the length of the bill, and it also provides that if someone is no longer employed, permitted, or licensed by the state, then those fingerprints are removed from the database within 10 days. So there's a period of time, a very short period of time, in which those fingerprints are removed, and that's for their own protections, because it's not intended to be a long-term retainage unless the person stays employed for a long period of time. This obviates the need for reprinting on a periodic basis. State law for various agencies require fingerprinting renewals at 1 year, 3 years, and 5 years. They vary. And so within that period of time, there's no way for the agency to know if their employee has engaged in something that they would not want their employee to engage in unless the employee voluntarily provides that information. But this would actually allow for it real time. The GBI has information about occurrences which they have seen, whereby there's been significant time delays between the incident which triggered the incident versus when the employee reported and was later terminated or discharged or disciplinary action was taken. In addition to that, the length of the bill, frankly, the bulk of the bill is the first 2 pages. I mean, that's the essence of the bill. The rest of it is to go through the code, and with Ms. Travis, with her assistance and that of the GBI, we've gone through and every single place where there is a code provision that says you have to have a fingerprinting on a regular basis, like every year or every 3 years or every 5 years or 24 months, whatever the language is, there's a carve-out that says unless your agency subscribes to this provision in GBI. So if DFAX, and only if the agency chooses to subscribe with GBI for this service, would they have the exemption. Otherwise, the law continues as it is currently, and there's no change in the law. So it would just provide for efficiencies, a more real-time check on the safety and the criminal activities of employees that have engaged in those activities, as well as I think minimize liabilities for employees of the state that may, or contractors of the state that may have engaged in an activity they should not have. That's the sum of the bill, but it's also the reason why it's so long. I'm happy to take questions, and I think that Ashley Fielding is here with from DBH. Sorry, Ashley, what's with DFAX? And okay, but she may speak broader terms of that, and then I'm not sure that there was, someone may have come in from driver services, but I'm not sure if they're here today or not. So, with that, I'll be happy to take questions from the committee, and then I will come back and circle back to try to see what concerns were raised at this meeting at a later date.
Great. Any questions for the author? I've got a couple I want to just kind of speak to, questions that we don't have to sort out this afternoon, but this seems to be open to really any agency. And what are the agencies that are required by law to collect this? I want to understand what we've got that we require by statute, and then what we're sort of authorizing at an agency choice to require. And then if the agency chooses to require it, what are the conditions in which they could do that? Or could it be any contractor for any reason? Just want to kind of explore what the universe of people that could be involved in this could be.
At this point, we're just impacting those which are statutorily required to do a background check. So it would not be anyone other than that, and it's lengthy. From alcohol licenses to banking and finance, to Secretary of State brokers, dealers, and investor advisors, World Congress Center, sheriffs, candidates, the personal ID for judges. There's bondsmen. DECAL has a list of requirements for background checks. Firefighters, public schools, all teachers they have an initial background check that's done. Guardianships and conservators. Department of Community Health has a long list of requirements. EMTs, insurance licensors, attorneys for bar admission, law enforcement, DVHTD, dentistry, DDS, SOS, various individuals that are regulated by SOS, from hearing aid dispensers to massage therapists.
I'm with you. I just wanted to just make sure that it's a defined list of agencies, and I want to just as we go through the process, make sure I don't know if there's any boundaries we want to put on. Can the Georgia World Congress Center Authority require, the maintenance and trash removal janitorial contractor to provide these things? I just want to be sensitive to what that we know what we're doing, and we're we understand what the boundaries would be for that.
We're not altering any of the existing boundaries, but we are providing for this real-time update.
From an agency perspective, we're not altering the boundaries.
That's correct. So whatever their current boundaries are, they will continue doing that. They'll just have the option to subscribe rather than getting a report every year, 3 years, or 5 years.
Thank you. Representative Price, question.
Thank you, Mr. Chairman. Currently, then, are these fingerprints held in one place? Is this?
No, ma'am. We're not. The state is not authorized, unless you adopt this law. The state is not authorized to maintain fingerprints of anyone that is not charged with a crime. So these are individuals that are just employees or contractors or licensees or permittees or that the state has hired.
And they would only be in that one location?
That's correct.
So,
and the law makes it clear that they have to be kept separate and distinct in two separate databases, secured, so that there's no commingling of that information with existing GCIC.
So if you lost or resigned, what have you, from a job that had required it,
yes,
and then they've removed them, and then you go somewhere else, and that job requires it, you have to pay for your fingerprinting all over again.
And yes, ma'am, that would be the case, unless you're unless to transfer. But as the bill is written right now, yes, ma'am, that would be the case.
And is that not possible, or
oh, sure,
can a person possess their own fingerprints? I mean, can you take it with you?
Well, no. I mean, obviously you possess your own fingerprints, but as far in terms of asking for a transfer of them, let me look at that question, and if it's not covered here, that may be something we should add to it, because it may allow for an interagency transfer of those. But this deals with right now. It's on lines 42. It says removal of fingerprints for the section within 10 days of being notified that the individuals whose fingerprints were retained is no longer employed, volunteering, and list out all those. So we don't have I don't believe there's a transfer provision in here.
But the technology would allow for it, would it not?
Well, it would be really just it'd really be if I move from, if I'm part of the Department of Revenue and I'm moving from Revenue to, the Department of Banking and Finance, then it makes sense to be able to say, I'm leaving this job, but I'm taking this other state job, so don't remove the fingerprints. And therefore I wouldn't have to re-fingerprint. Now, as it is right now, you would have to just re-fingerprint.
Mm-hmm.
It's a good question, though, and I had not thought about that issue.
Chair recognizes Representative Gonzalez for a question.
Thank you. Can you just clarify for me one thing when we look at biometrics and security and you're having these fingerprints that are being kept by this particular entity or agency? How long are they kept? Are they kept indefinitely as long as the employee is there?
That's correct.
And does the bill go into any security measures as for those fingerprints?
It does. It is mandated that the exact language is. Let me make sure I find it here for you. Yes, on line 28, it requires the agency, the GBI, begins on the proceeding that such fingerprints shall be retained and maintained securely and separately from records relating to the identification of criminals. And it's provided further that the center shall not file or retain fingerprints submitted for this purpose for obtaining or renewing weapons carry licenses.
And so is the only concern here how long you can keep the fingerprints after the individual has left the position?
No, that concern is addressed in lines 42 through 47, where it's a 10-day retention once they've left or they've terminated their permit or license or contract with the state. But the issue is being able to have real-time monitoring of individuals that may be handling sensitive information, personal identifiable information, overseeing and supervising children, the elderly. So those agencies may want to have this in order to keep a closer watch on the activities of the employees, whereby if they engage in a criminal activity, that may be grounds for termination, and at least to, with respect to children, to protect the placement of the child.
So I'm going to ask you to just bear with me because I'm still not understanding what the core is of the bill in terms of if you're saying that it's to retain these fingerprints for what purpose? And
For ongoing monitoring of the employees, contractors, or licensees of the state, so that if they engage in a criminal activity and they are picked up and fingerprinted for criminal activity, that information will then be triggered to go back to the employer or the contractor, so that they'll know that they have someone that may have been picked up for a crime that we may not want, if it's child molestation or something like that, and they happen to be working for a child caring institution, then I think that's important to know as quickly as possible.
so that person is picked up, he's fingerprinted for whatever crime it was, he's identified as being employed by this agency. Automatically these fingerprints then go to the agency,
No.
or a report that he was picked up goes automatically to the agency?
The report.
Okay, and it's based on a match between the fingerprints that were taken at the moment that he was arrested or detained and the fingerprints that are actually in the agency?
That is correct.
So these databases have to communicate in some way?
They will, yes.
Thank you.
Thank you for the questions. And again, it's discretionary as to the agency, so it's only if the agency chooses to subscribe, and then we leave it to the agencies to set their procedures and protocols as to which employees would need to be, would qualify, and which would not, or contractors or licensees, permittees. Mr. Chairman, I'm going to beg to be excused.
on the part of the state. Some folks have come to me and said, hey, Representative Sester, 623, I understand what Chairman Welch is trying to do, but, we can remove that from state retention, but that's something that's held, I guess. I think there's a recognition that'll be held by FBI. That'll stay in their system. Has anyone brought you a concern about that? Or?
No, that's the first that I've heard of that, and I think the experts from GBI can probably address that question, but it's my understanding that no, these are retained by GBI and our own state database.
Okay. I think the privacy concern was it goes up to the. I think as you broaden the base of people that can be brought in, if it's undefined, that was brought to me today earlier. I just want to share that with you as the conversation progresses. Any further questions from members of the committee? Hearing none, Chairman Welch, thanks for making the presentation.
Thank you.
Again, we're working off 7889S. Right now on the sign-up list, I only have one person signed up to speak. Does anybody else want to speak? I've got Mrs. Aisha. Is it Aisha Yakub? Anyone else want to speak to 623 while we're here? Good. Yeah, get her on there, yeah. Ms. Yakub, please. Ms. Yakub, if you could state your name and pronounce it properly, forgive me for that, and tell us who you represent today.
Thank you, Chairman. My name is Aisha Yakub. I'm with Asian Americans Advancing Justice Atlanta. Thank you for the questions that you asked. They were very similar to what I was planning on asking. I guess my other question is just jumping off of what you had mentioned about the information that is being sent up to FBI. I would like some clarification as to what happens with the data once it has been sent up to the FBI, if they have access to hold on to it indefinitely, or if it would also be removed from their database. That's just a comment that I had, if that can be clarified in here, if possible. And then the other question I have is, it also mentions individuals that are volunteering for agencies. So I will give you the example. When I was in college, I on and off volunteered for an organization that worked with adults with developmental disabilities. I had a background check when I first started doing it, but I never ended my volunteer term. I would volunteer once every couple of months. And so does that mean that for the 4 or 5 years that I'm volunteering, my fingerprints would be held? What if I don't officially end my volunteering? Would that stay in the system indefinitely? I think that places a huge burden on organizations that regularly call in volunteers, because then they would be subject to having their privacy potentially violated in the future. So that was my other concern. And then my last one was, how do agencies actually notify GBI about the termination of an employment or the termination of a volunteer term? And I think that's a little bit problematic, because if you're giving the organizations or the agencies the opportunity to develop their own policies and procedures, that might not actually be in the best interest of the individual, because it could take longer than 10 days by the time they report the data. So those were a couple of concerns that I had, and just also adding on that privacy argument that you had talked about. I think for the larger community that is going to be fingerprinted, I understand the need for checks on people that have committed crimes, but for the larger population, I think it is still a valid privacy concern.
Any questions for Ms. Yakub? I would ask you, would you agree that there are certain circumstances in which taking fingerprints for state employees is appropriate?
I do, especially when it comes to schools, children, and elderly individuals.
Okay, so from your vantage point, it's more of a threshold question.
Yeah.
Who should be and what should the conditions be? You're not disputing that there's an interest.
I would actually recommend that those standards be set by the state rather than leaving it up to the individual agencies.
Okay, thank you. Any further questions? Seeing none, thank you. GBI was referenced in that. Does GBI, do you guys want to stand sort of in place and speak to this, or you're welcome to come up and speak to this? If you'd like to, you're welcome to give us a rapid fire. I do have Ms. Cooper would like to speak, but I'd like to get some context from GBI if we could. Ms. Miles, welcome.
Thank you, Mr. Chairman, members of the committee. We have been working with Chairman Welch in regards to the fact that, of course, we are oversee GCIC. We've been supporting him in the area of the subject matter expertise. So I have the Deputy Director of GCIC here with me, Terry Fisher. She can just kind of let everybody know our role.
Ms. Fisher, welcome.
Thank you very much. So your questions, or what would you like me to address specifically?
I guess, members of the committee, do you want to address any questions specifically to GBI? I've got a couple myself, but if you guys have some, I'll let you. My question is, what is the framework? Are there enumerated positions? Are there limitations on the contractors, for example? I think it's one thing for a state employee and a stated agency. As we talk about contractors, what limitations are there in statute that could limit this from becoming just a bigger?
You would have to be
universe?
authorized by the FBI to do a, what we call a 92-544 submission there. So, we just couldn't enroll you, willy-nilly. It would have to be, in statute to get you into this fingerprint database. And then it would be up to the agency to make a decision as to whether to enroll the person in this, what we call wrap-back, application.
What's the cost of doing each one approximately? Do you have a sense of that?
We've got a standard cost that's given out. Hold on just a minute, and I can tell you. We don't. The FBI has done a review of this, and they didn't anticipate. They've got a national program that they have established. They don't anticipate charging any additional above the standard fingerprint fee that is charged right now, and we don't anticipate that either.
So is this a $35 thing, and what's the order of magnitude here?
Okay, hold on just a minute. Let me get exactly what those costs are. And I've got it here. Hold on.
Take your time.
Currently, right now, for a state of Georgia fingerprint-based background check, we charge $27.75, and then for a state and federal check, that's $39.75.
Okay. Does that I guess that floats around there, goes up periodically, but it's in the $25 to $40 range basically?
Yes, sir.
Okay, gotcha. No, that means that the agencies, the F people themselves that actually take the prints and import them to you guys, or do you guys take the prints yourselves? How does that?
No, the GBI does not take prints. We, either there's, a lot of times it's at local law enforcement agencies may take the prints, and we also have what we call the Georgia Applicant Processing Service, and those are print locations that are scattered throughout the state of Georgia, and a lot of our big state agencies utilize GAPs to have their applicants fingerprinted there.
Sure. What percentage do you think are employees, and what percentage do you think are contractors in the state?
I do not know.
Is it overwhelmingly one or the other? Is it are contractors the exception, or contractors the rule? And
You would have to ask the individual agencies that employ these people. They would have more information on how much of their staff are contracting staff versus state employees.
how many total folks do you have in the database right now?
We've got 4.2 million individuals that are in the criminal database.
So the criminal database for criminal investigations and this database, they're basically in the same place then? You just kind of manage them in the same database?
Well, currently right now, we don't retain applicant prints. We don't have that ability to do that. When your fingerprint, when you come in, you apply for a job with the state and you're required to be fingerprinted, we would come in, we would search that information. If applicable, we would send that on to the FBI. We would search it there, and then fingerprint results would come back, and they would go to the agency making the licensing employment decision, and that's it for your fingerprints.
So if you get a hit, then something's raised, but we don't retain the prints
No.
in our database?
No. And this is what this bill would do, give us the ability to retain those fingerprints at GBI.
Okay. I take it the FBI, when they get them, they retain every print I guess they touch?
No, they do not.
Really?
No, that's right. So they don't have
Are you, does that get shifted over to their cousins in NSA and they preserve them over there?
I can't speak to that, so.
I do think people, personally, when these powers are enabled vis-a-vis state law, I do think folks want to have a sense of what happens to it upstream.
Yep.
So you're confident FBI does not maintain these? They simply do a comparison and then it
That's
just...
right. Yep. They don't have the statutory authority to do that either with Georgia prints. Now, some states have enrolled in RATBAC. I believe Utah is one of the states that retains their fingerprints at the national level there, as well as I think Hawaii was moving towards that, but they haven't done that yet.
So if you had to characterize the nature of this in two sentences, what value does this give us from a GBI perspective?
From the GBI perspective, I don't know so much from our perspective, but for those people who are making license and employment decisions, it gives them the, I guess the good feeling that they know what those people they have employed, what they're doing. You know, what this thing is to do is, if I, like you said, if I go out and get arrested at some point in time, for a child molestation or something like that, that daycare center or, the licensing agency for that would get notified about that, so that they would know that that person had done something. Now, whether they make the decision, whether it's a crime that says, okay, well, yeah, that's, you know, Terry was out drunk and, you know, and she got DUI and things like that, that may not affect the employment decision. But if I was arrested for child molestation and I work in a daycare center, oh, that's going to send up a red flag. And so it just gives you the, you know, the confidence that you know what the criminal history is of that employee.
So if the employee had their information being maintained by GBI and they're arrested for something, how long is it going to take from when they're actually printed at a police precinct to get a hit and to get a link that they're a state employee?
Probably 2 hours or less.
2 hours. So we'd have almost immediate notification.
Yeah.
And then you guys, is there a protocol for you to notify state agencies? Or does that need to be?
Currently right now, no, because we don't have this program in place.
Okay.
So,
But in essence, this allows us not just to check people when they walk in the door, but to check them against
an ongoing check,
process.
Yeah.
Okay. Any questions for GBI? Ladies, thank you for being with us.
you.
Appreciate it.
Good afternoon, Mr. Chairman, members of the committee. My name is Ashley Cooper. I am the Deputy Commissioner of the Georgia Department of Human Services and Chief External Affairs Officer. I speak today on behalf of our Division of Family and Children Services and our Division of Aging Services and our Division of Child Support Services. We have about 9,500 employees in our department, many of whom have direct access to clients who are some of our most vulnerable in the state of Georgia. We've been working with Representative Welch on this issue and similar issues with regards to our providers in the DFACS arena, who run child placing agencies and recruit foster parents or child caring institutions for about 3 to 4 years at this point in time. He initially approached this subject in a manner to reduce the burden on our providers of having to fund what is sometimes a $50 to $54 fingerprint check every 5 years. We require a fingerprint check of our our foster parents every 5 years. Some individuals that we license, we also have different time frames for that as well. But we also did not want to compromise child safety. The way that this proposal is drafted, to our knowledge, if implemented, we believe it would have the benefit of improving child safety because we would be able to have information in that 5-year time period, and we wouldn't be burdening our providers with the additional cost of the fingerprint every 5 years or when they change jobs.
So in essence, it's a lower cost product because you collect it once, but it gives you near real time monitoring, in essence, of the criminal status of your people in the sensitive jobs.
That's correct.
Plain and simple. Okay. What questions do we have from members of the committee? And this is a big policy question. This is not an inconsequential policy we're discussing here. Not to over dramatize it, but I just think it's a. Having no questions, Ms. Cooper, any sense? Are there things written in statute that prescribe who may have their prints taken, or is it really just an agency by agency policy?
It's in the statute. You have to have individual purpose codes in the statute that are approved by the GBI for the types of people that you would check and the reason, the crimes that you would check them for. This conversation started a few years ago as to whether or not the Department of Human Services could share fingerprint information with the Department of Juvenile Justice. As you may know, the Department of Juvenile Justice contracts with many of the same providers that the Division of Family and Children Services works with to place children. We are not able to share that information because we are not deemed similar agencies by the Federal Bureau of Investigation. So the only option that we would have is for one agency to conduct the criminal records check and then provide the other agency with a letter just to say whether or not they were approved or not. That's not acceptable to us because that keeps one agency that is essentially hiring an individual from knowing what's in that criminal background check and from having the discretion of deciding whether or not those crimes that are on that individual's background report are going to disqualify them from employment.
So with the way the current code operates, there are certain positions that you're mandated you have to get prints for.
That's right.
Is there any prohibition for saying beyond this you may not get prints? Do you know of any in statute?
Can you clarify
Okay.
what you mean by that?
Thou shalt take prints on these 3 job titles. Is there anything in the statute that says you may not take prints on anyone but those 3 job titles? Are there any limitations there?
The GBI could probably clarify this best, but it's my understanding that you have to have every single person that you pull a fingerprint check on, you have to have specific authorization to do that for that individual in their job code.
And we may need to explore that as a committee. I just don't want to. I will get these questions asked of me as this is moving through the process. I just want to make sure I sort of understand the boundaries.
Sure.
But thank you for being with us today.
If there's any way we can be helpful, let me know.
Thank you. Anybody else from the public want to be heard on this? Anyone else? 623. GBI, thanks for being here today. I know it takes time out of your schedule to sit through all these hearings. We do lose the room today at 4 o'clock, which is 10 minutes ago. So with that, I want to recognize for real quick, very quick rapid fire. Representative Oliver has a bill 837 that's not going to be heard today. She does have changes. Is there anybody here that has a question about 837 that you would have asked had we heard the bill? Okay. Representative Oliver, can you give us a 1-minute summary, and then I'll let Mr. Weaver share maybe a 1-minute concern.
I don't know how many other people are getting have signed up to testify. Georgia's leadership has been very committed and successful in taking a lead on rape kits, enhancing the rape kit funding and enforcement. This bill 837 is offered as the next step of the rape kit analysis evaluation to give additional information and opportunities for victims of sexual assault to get specific information on the status of rape. It's part of the national discussion about how victims can be treated and included in the process. Today, with this Travis assistance, I've prepared a supplement for yourself, but also had additional conversations with the district attorney and the cities, and their suggestions are good ones, and I want to evaluate exactly how to make some changes to this. I just didn't want to be discourteous to the folks that may come to
Yeah.
testify today.
Appreciate that. With that said, Mr. Weaver, you got 60 seconds. Share your concerns, and you can certainly see Representative Oliver afterwards to share those in more detail.
Actually looking at some that Ms. Travis is very familiar with my concerns with that. I just wanted the committee to find that the result to match what Representative Hudson did back in 2016 with the improved way of job knowing and this added to that. I provided the definition of the topic.
Super.
I did want to leave out the date of implementation of the Classic Cities. I need some more attention on lines 43 and 47. But I do want to bring good stuff to the committee for consideration of the
You will have one next week, and appreciate everyone being here. With that, we stand adjourned.
Estevez.
All righty, we're a little late, so we're going to go ahead and get started. If you would, as we always do, please bow your heads and we'll begin with a word of prayer. Lord, we once again pause and acknowledge you and thank you for all the blessings that we do have. We ask you now to give us the wisdom in this room to do what is best for this committee and the people of the state of Georgia. Amen. Mr. Estration, come forward, sir. Which one do you want to tell us about first?
It's all right, 896 first.
Mm-hmm.
And if I could have Mr. King join me.
Absolutely. Anybody you want.
Mr. Chairman, just to give a little background, actually, I'll kind of preface both bills. House Bill 896 is an update concerning the Uniform Adult Guardianship and Conservatorship Proceedings Jurisdiction Act, which was passed by the General Assembly 2 years ago. It was an attempt to adopt provisions from the Uniform Guardianship Code and was passed out of this General Assembly, has been in effect since then. This is cleanup language to help address some issues that have arisen since then and to provide clarity in the law. In a minute, we're going to talk about the companion bill, House Bill 897, which is cleanup language for the Uniform Power of Attorney Act, which was passed last session. I mention all this background so that you all know that I've had an opportunity in the run-up to this bill to have all interested parties meet, the fiduciary section of the bar to review and actually draft many of the changes, for a complete discussion to take place, all interested parties to be in the same room. To my knowledge, there is no opposition whatsoever to any of this legislation. So we've aired out any questions or issues that might have been there, and that is to both bills. That's to my knowledge. And Mr. King is certainly, from my interactions, I can attest, an expert in this area, but also I believe, do you hold a position with the fiduciary section as well?
That's correct. I serve on the legislation committee of the fiduciary law section.
This is the state bar bill for this.
Right.
Okay.
So just to maybe, Mr. King, it might be quickest if you could just walk us through the bill.
Certainly, I'll be glad to do that. And as Representative Oliver mentioned, this did go through the State Bar's Advisory Committee on Legislation. It has been reviewed by the probate court judges. It has been reviewed by Professor Radford, all of whom I believe had various suggestions that have been incorporated into this. When the legislature adopted the Uniform Act 2 years ago, which Representative Estration introduced, and we appreciate that. It brought our law into line with the laws of the overwhelming majority of our sister states. This bill, House Bill 896, would not change any of the provisions of the Uniform Act, which is now codified at Chapter 11 of Title 29. Rather, it makes some small but significant changes to the previously existing provisions of the Georgia Code in order to make sure they mesh with one another. The Uniform Act obviously was written for adoption nationwide. It was not written with a view toward any particular state's code. And I'll be happy to answer any questions about any specific sections. But the current provisions, for instance, under Section 1, the current provisions of the Guardianship Code provide that no guardian other than a guardian ad litem would be appointed for an adult except under Chapter